Appeal, MTH and E.ON Climate and Renewables UK Robin Rigg East Limited.
Before we start, I would like to apologise on behalf of the court for the confusion which took place over the question of permission to appeal, particularly to the respondents. Mr. Marion.
My Lords, in this appeal I appear for the appellants whom I'll refer to as E.ON, together with my learned friend Mr. Buckingham, my learned friend Mr. Stretfield James, together with my learned friend Mr. Chennels, appear for the respondents, to whom I will refer to as MTH. Lords, may I start by offering an overview? I had in mind to make a few words of introduction. Following that, I wanted to touch briefly on the structures in question. Thereafter, I had in mind to draw your attention to some references in the conditions of contract. Then J101, the code which was incorporated into the technical requirements, and then lastly the technical requirements themselves, before turning to submissions.
Thank you.
Lords, by way of introduction, this case raises a short point of construction arising under a contract for the design, manufacture and installation of the foundations for a number of marine wind turbines. Put shortly, the question for determination is whether, in relation to a warranty of fitness for purpose, the technical requirements identified the purpose for which the foundations were required. My Lord, we formulate the question in that way because the parties in this case adopted a drafting technique which placed the warranty of fitness for purpose within the conditions of contract, whilst the purpose itself was to be determined from a technical document, the technical requirements. It doesn't appear to be in issue that technique, that drafting technique, is not uncommon in the construction industry. But, my Lords, the parties don't see the issues in entirely the same way. Might I invite your attention to the statement of facts and issues, and the issues at the back?
Yes,
Lords, that's core, tab D, at page 95.
Yes.
You see there the statement of issues. There are 5 of them. In other places they've been described as 1 to 5,
right,
rather than by reference to their paragraph numbers.
Yep.
The appellants see the principal issues being incorporated in 1 and 2 at paragraph 79 and 80, but the respondents regard the central issue as being that which we see at 4 was the effect of clause 8.1.10 and paragraph 3.2.2.2 of the technical requirements that MTH warranted that the foundations would achieve a life of 20 years. My Lords, you will have observed that my learned friends elegantly sidestep the question of whether or not a purpose could be discerned from the technical requirements. And, my Lords, that simply reveals the difference between how the parties see the issues. Lord, moving on, one further point by way of introduction, it's this: it's no part of my case to suggest a departure from the established principles of contractual interpretation. But I submit that there are 2 features of the present appeal which may be said to set it apart from the general run. Lord, the first is the use of the drafting technique to which I referred a moment ago. And, my Lord, the second is that the contract was, or appears to have been intended to be, what has been described as a contract of double obligation. Lord, that's a contract where the contractor is under an obligation both to comply with provisions as to how he should carry out the work and to achieve a particular result. Lord, I say those two features perhaps set the case apart from some of the decisions with which we are all familiar, but they do, particularly the latter, we suggest, inform the iterative process which is required, because at appropriate stages in that process, it would be appropriate, we submit, for the tribunal to refer back to the possibility that the parties intended that the contract should be one of double obligation. And in the present case, to refer back to the question whether or not the purpose for which the foundations were required was something which could be discerned from the technical requirements. Lords, moving on, the structures, and first, my lords, an apology. It seems in retrospect that it would have been appropriate for a photograph of one of the completed turbines, perhaps several of them, to be included in the papers, and they're not. My lords, what you do have is at the beginning of the Statement of Facts and Issues, that's core tab D.
Yes.
At page 17, a diagram.
Yes.
And my lords, the diagram shows the foundations and only the very bottom part of the superstructure. The superstructure comprised two elements, a turbine tower supporting above it what is known as the rotor nacelle assembly, which, my lords, bore the blades and the generator. If I might invite you to look at the diagram, yes, and see the bottom of the page. In grey you see the seabed.
Yes.
And above that in blue, of course, the sea.
Yes.
In black, the pile, cylindrical steel, not filled with concrete, so a little over 4.3 meters in diameter. Embedded about 25 meters into the seabed, leaving about 15 meters above the seabed. Above that, my lords, what you see most prominently is in yellow the...
When you say 15 metres above the seabed, is that 15 metres in the sea or 15 metres in the sea and the air?
Both, my lord.
Right, thank you.
Yes. In the diagram, the monopile is slightly above the surface level of the water,
yes,
and that's intentional, presumably.
It is intentional, yes.
Yes.
My lords, the transition piece you see marked in yellow, and if one were to see a photograph, one would see that they are painted yellow. That is about 8 meters in length.
How long? 80?
8 meters.
I see. So this is not to scale? Yeah.
This is not to scale, no, my lords.
Yeah,
not
you.
by any means. And, my lords, what you see at the juncture between the transition piece and the pile is marked in words and shown grey, the grouted connection, yes, between the two. The length of the grouted connection is 6.45 metres.
Right.
And, my lord, grout is cement material.
Yep.
And you see that there is a grout seal at the bottom.
Yes.
My lords, immediately above the top of the pile shown black, you see on either side of the transition piece a temporary, what is called a temporary support bracket. My lord, those were brackets fixed on the inside of the transition pieces, and they were to assist the transition piece to fulfill its objective, which is to enable the contractor to ensure verticality of the structure to which the turbine tower is then attached above. The temporary support bracket, my lord, was used for jacking purposes. Jacks placed beneath the support brackets and above the pile and adjusted to achieve verticality. Jacks removed upon completion, but not before the grout has been poured and allowed to My lords, the point has been made, as you will have seen, that the grout works not by adhesion, as one might expect, but by friction. My lords, above that, you see the transition piece, and at the top of the transition piece, you see black markings labelled flange connection with turbine tower.
Yes.
The lower part is the transition bolted flange. The upper part is the turbine tower lower flange, and they are bolted together when the tower is mounted on the foundation.
Right.
My lords, the structure above stands high. The hub height of the superstructure is some 80 meters above mean sea level, and the blades of the turbines are some 44 meters in length. Lord, by my arithmetic, the top is therefore, when the blade is in vertical position, some 124 meters above mean sea level. Lords, you only have to hear that to appreciate the loads which are imposed on these foundations. There is a significant vertical load as a result of the self-weight of the superstructure. But, my lords, the more substantial loads which are imposed on the foundations are in fact created by wind and wave conditions, which obviously affect the superstructure and cause a tendency to overturn the foundation, which it is required to resist. My lords, I had in mind to move on and to invite your attention to some points concerning the conditions of contract. My lords, some introductory points. Firstly, the contract documents. My lords, you will be ahead of me, but can I just assist in explaining how they work? For this, my lords, I invite your attention to additional volume I at page 229. My lord, it's behind tab I1. Lords, you see there form of agreement. It's marked Part B. The explanation for that is that Part A was the invitation to tender and the instructions to tenderers. My lords, in compiling the contract documents which were eventually agreed, they dropped A and they added the tender documents. And, my lords, one sees that if one turns the page to page 230. We are there in Part B, the form of agreement.
Yes.
And the documents are listed on the lower part of the page. My lord, Part C, list of definitions, we have that at tab I2. Part D, conditions of contract, we have those at I3. E is commercial schedules, we have those at I4. We don't have Part L. G, H, I, J, and K were the employer's requirements. Of those, we only have Part I, technical requirements. My lords, those are at tabs in this volume, I5 to I10. It is singularly unfortunate that it should happen that Part I of the contract documents is assembled in a volume which is called additional volume I.
So we've got II.
I'm sorry. Yes, my lord. My lords, we don't have the annexes and we don't have the volumes of the contractor's tender return. My lords, to make good my point that G to K are the employer's requirements, can I invite you to turn to tab I3 at page 255. My lords,
Could you give me that page again?
I'm sorry,
255.
I3 255. It's clause 4.3, the priority clause. Interesting in itself, of course, but for present purposes, there is a listing of the documents forming the contract, and at little d you see the employer's requirements, and then brackets at parts G, H, I, J, and K. So that, my lord, part I is the technical requirements, and it forms part of the employer's requirements. My lords, you see the priority clause and its terms. It applies only in the event of any inconsistencies, and is therefore in a standard form. You may wish also to notice in passing 5.4, at least the first sentence, the agreement to be taken as mutually explanatory.
What's that mean?
What does that mean, yeah?
Sorry, but to my right and my left, as with one voice.
Yes.
The question is, what does that mean?
Mutually explanatory.
You read them all together, does it mean? Yeah.
Yes, it means you read them all together. I think it's a contractual version of the iterative process, my lord.
Oh, right, I've approved that.
Maybe we'll find out what it means then.
My lord, the other introductory
I'm
point.
sorry, I'll read that again.
My lord, the other introductory point is that it's common ground that the contract documents are not in standard form. There's evidence of borrowing from a standard form to be found in the conditions of contract, but that is a matter which is common ground between the parties. My lord, we have that in the respondent's reasons for not granting appeal. That's core B1, page 54, at paragraph 15.5. My lords, no need to turn it up. My lords, then within the contract documents, I had in mind first to invite your attention to the provisions which address fitness for purpose. There are, of course, two, my lords, 8.1.10, as I shall call it, clause 8.1, little Roman 10, and, my lord, clause 32D, clause 30.2, brackets little d. Might I start with 8.1.10? My lords, that is at tab I3, page 260. My lords, you will have looked this up already and no doubt noted 3 points about the clause. Firstly, that it uses the expression fit for its purpose, but the words are not capitalized. And in that respect, they're to be distinguished from the defined term fit for purpose, to which we'll come shortly. Secondly, my lord, you'll see that it refers to the specification. My lord, that wasn't one of the contract documents which we just saw, but it's common ground that it refers to the employer's requirements, which include the technical requirements. And my lord, thirdly, you'll have noticed that it refers in the last 4 words to good industry practice. The obligation imposed on the contractor is to carry out the work so that each item of plant and the works as a whole shall be fit for its purpose as determined in accordance with the specification using good industry practice.
And is that defined?
It is, my lord. That's a defined term to which, again, I should draw your attention that definition is to be found behind I2 at page 236. My Lord, it runs to several lines. Would it be convenient to the court if I invited your lordships to read it? My Lords, there's a difference between the parties as to how that expression, where used in 8.1.10, should be interpreted. I'll come to that in due course.
Right.
But putting it shortly, my Lord, the appellants maintain that it goes to the approach to be adopted in seeking to identify the purpose when looking at the technical requirements, whilst MTH contends that it is relevant to the issue of fitness. My Lords, I put that in that way because that's how it appears. For the note, my Lords, that is MTH's case, paragraph 46, brackets 3, and the page number is core, volume E2, sorry, tab E2, page 146. Lords, might I then invite you to look at clause 30. My Lord, that's tab I3, page 290. Clause 30 is a defects liability regime which provides for the notification of defects towards the end of the works, the objective being that the contractor shall return to site, if he's not there already, to carry out appropriate remedial works. My Lords, the reference in particular is 30.2 brackets little d.
Thank you.
And the obligation is upon the contractor, upon being given notice, to make good defects arising from, and then looking at little d, works not being fit for purpose. There's a proviso which I think needn't be addressed at this point. My Lords, in respect of that provision, several points arise. Firstly, there is a reference to fit for purpose, but this time we have the capitalization. And my Lord, that takes one back to the definitions part C. This is tab I2, page 236. My Lord, the definition is at the top of the page. It has something in common with 8.1.10. Fit for purpose means fitness for purpose in accordance with and as can properly be inferred from the employer's requirements. My Lord, back, if I may, to 32D, that's tab I3 at page 290. The other point, my Lord, is that quite independently of 8.1.10, this provision is such as to impose upon the contractor potentially, and subject to notice, the obligation to make good work which is not fit for purpose.
Yes.
And Lord, the third point to note in respect of 32D and the definition of fit for purpose is that there is no reference to good industry practice. So that the reference to good industry practice is to be found in 8.1.10, but not in 32D or in the definition of fit for purpose.
Right.
My Lord, the other contractual provisions which have drawn attention in the parties' cases concern the exclusive remedies regime and the saving for claims for latent defects.
Yes.
My Lords, to trace through the various clauses is, we submit, unnecessary given the position at which the parties have arrived. Comparing the parties' cases, my Lord, it appears to us that the respondents accept that whilst there is an exclusive remedies provision, and there are provisions for transfer of risk, defects, liability period, and final certification, nevertheless, those provisions incorporate a saving for latent defects. The result is that even after the limitations of liability imposed by the other clauses have been applied, nevertheless, it is open to the employer to advance claims in respect of latent defects.
But even after the 48 months?
Even after the 48 months.
I thought they didn't accept that.
My Lords, it may be that they don't. It had appeared to us that they do.
See, I mean, I thought you were arguing that there wasn't any point in the saving of latent defects unless it continued after 48 months. But I'm not
Yes,
sure. I'm not sure why that's so. I mean, why can't latent defects be something which are relevant in the period between the issue of the certificates of final completion and the certificate of, what is it, quality, satisfactory quality, which
Yes,
happens after 24 months,
yes,
and the 28 and the 48-month period?
yes.
Why can't latent defects be relevant in that period rather
Because
than
it's not-
after 48 months?
Because, my Lord, it's a limitation clause. We're concerned with a limitation clause, and the matter is left open. Perhaps it would be convenient to look at 33. My Lords, it's it's I3, page 298. And, my Lords, this is concerned with the conclusive effect of a final certificate for payment.
Yes. Well, that takes place after 24 months, doesn't it?
Yes, my Lords.
It's 28 days after the defects liability certificate, which is itself issued 28 days after the expiry of 24 months. Yeah. So that simply says that latent defect liability can continue after the basic defects liability period
Yes.
of 24 months.
Yes.
But does it say that it can continue after 48 months? Because somewhere there's a clause which purports to remove all remedies on one view after 48 months. Where is that?
That's 42.3, my Lord, on page 304. Sorry, 303, I should say.
Yes. 42.
42.3.
Yes. Well, where is the 48 month?
The 48 months, my Lord, is
There's a stopgap.
yes, it's page 291, my Lord. It's the end of 30.4.
Yep.
And, my Lords, the short point is that looking at 33.11,
You've got latent defects, is that right?
yes, and, my Lord, it is expressed generally, not limited by time.
Well, I mean, 3311 is simply providing that the final certificate of payment after 24 months doesn't preclude your remedies for latent defects, but on the face of it, 30.4 might be read as covering all defects. Liability for defects shall cease 48 months from the date of takeover, the only exception being corrosion-resisted coating under Part E, Schedule 1.5, which is has a 5-year period.
Yes. Well, my lords, the clauses present a conundrum. One has the exclusive remedies clause. One has the apparent limitations of liability, including the 4-year period to which you just referred me. And then one has clause 3311. And the question is how to read them together. And our submission, lords, is that, for example, so far as 30.4 is concerned, it should be regarded as confined to it can't be regarded as prevailing over the provision at 3311, which expressly exempts latent defects and other matters from the final.
What you say is that the longer defects liability period ceases in relation to all defects, but that doesn't prevent the provisions of 3311 taking effect.
Yes, my lord.
I mean, 3311, yes, 3311, yep. I mean, 30.4 is merely concerned with an extension. All it's saying is that extension provision ends at that point. It doesn't mean that the final certificate. 30.4 is an extension for the benefit of the employer.
Yes, my lord.
And that benefit ceases in relation to all defects, but it doesn't mean that anything else ceases, including the effect of the final certificate.
Yes, my lord.
Yeah. Yeah, okay.
My lords,
Is limitation relevant in the particular circumstances of this case?
no, my lord.
Looking at the chronology, it didn't seem to be.
No,
But the point is that the argument against you is that it doesn't. Your argument doesn't work in theory.
Yes. The idea of a 20-year
A 20-year liability
doesn't
wouldn't work if there was a 4-year limit, but you say there isn't.
Precisely.
Yeah. So 33.11 floats free.
My lords, before leaving the conditions of contract, I had in mind to just mention some evidence of the parties' approach. Would you be good enough to look at the contents pages of the conditions? That's tab I3, page 244.
I suppose there is just one other question, actually. 33.11 frees latent defects from the effect otherwise of finality, which arises from the final certificate of payment. But bearing in mind 42.3, the exclusive remedies clause, what basis is there for any liability in respect of latent defects except a defects liability period, i.e. 30.2 or 30.2 as extended by 30.4? Is that a different way of putting the case against you on this point?
My lord, this is a analysis that we have undertaken in the case, my lord, at yes, it's page 118, my lord. This is the E.ON, the appellant's case, for tab E1, page 118.
Paragraph?
And, my lords...
Which paragraph is it?
Yes, my lords, I'm... my lord, it's the lightest cast paragraphs. There are two of them. At 74, my lord, we say light is cast on the meaning of the expression contractor's liability for defects, where it appears in 30.4. I'm sorry, my lord, I should have started at 72. The final paragraph of 30.4 is set out. We say there's an issue as to the meaning of the expression liability for defects. The question is whether it referred simply to contractor's liability physically to make good defects, or whether it extends to the contractor's liability and damages. And we make the point at 74 that light is cast on that by the exclusion for latent defects in clause 3311. And, my lords, we then go on to refer in paragraphs...
That's not right, is it? I mean, clause 3311 serves a perfectly useful purpose, namely of ensuring that you can continue to rely on the defects liability provisions of 30.2 so long as they exist.
Yes.
After 24 months.
Well, my lord, that's the view that, my lord, you put to me somewhat earlier, that the saving for latent defects benefits the employer only for the remainder of the 4 years.
Well, yes, but the problem which isn't dealt with in your cases is that there isn't any liability under this contract for defects except under the defects making good defects provisions.
Yes.
Because you've excluded all ordinary contractual remedies for
Yes.
damages, etc.
Yes.
That's what's said against you.
Yes, that's what's said against us. And the point
So
that we're...
how do you deal with that point? The latent defects provision would have an effect on that analysis, namely of preventing the final certificate of payment, barring a claim to invoke the making good defects clause during the period after 24 months and before whenever it expired, which is basically 48 months, or might be 5 years in the case of corrosion-resistant coating.
My lords, our submission is that if one identifies two kinds of remedy in respect of defects, one is a right to have the defect put right,
Yeah.
and another is to have to recover damages in respect of.
No, but the damages one is what's excluded by 42.3.
Well, yes, my lord.
You can't recover damages at any time, as I see it, whether within the 24 months, 48 months, or after.
Yeah. On the face of it, my lord, yes. But this is the point that we seek to address at paragraph 76 to 78 of our case. We say there's an issue as to whether clause 42.3 had the effect of excluding the employer's right to recover damages for latent defects. The question is whether the right to recover damages fell outside the group of remedies, which are, for the purposes of 42.3, treated as provided for in this agreement. In other words, my lord, we are advancing the submission that although the contract does not expressly recognise a claim for damages, the proper construction of the contract, having regard to clause 3311, is that it must, in fact, include a remedy for damages.
But no, clause 3311 isn't dealing with that at all, is it? It's simply saying that there's no time bar in respect of latent damages after 24 months, i.e. the final certificate of payment is not conclusive as to latent damages. It certainly isn't conferring a positive remedy in respect of latent damages.
Well, my lord, latent damage is a matter...
Latent defects, sorry.
Latent defect is a category of defects which are unlikely to fall within the clause 30 defects liability regime because by definition they will be latent rather than patent. and won't be the subject of notice.
Well, it depends how, I mean, at some point they always become patent, and the great
Yes.
question is how long you're prepared to take the risk of them. And
Yes.
it appears here that 24 months was regarded as too short, but 33.11 said we'll give you a bit longer. The question is simply how much longer. On the face of it, they might be caught by 30.4. Maybe
Well-
that's the better argument, that they fall outside 30.4. Although, again, that's not what 3311 actually says,
No,
because 3311 is simply dealing with a rather narrow point. What is the effect of a final certificate of payment?
yes. But, my lord, the broad point is this, that by referring to claims for latent defects, we would submit, it impliedly recognises that there is a remedy in damages for latent defects, which is not caught by the other provisions.
In a sense, there's a question about latent defects, which you may have a problem about in light of the closing words of 42.3 if you're outside the time limit. You say the time limit, there's no time limit problem here on either side's case.
No, my lord.
And
The notice was given
may,
before the...
it may influence how one characterises the precise breach of contract that you allege, whether it's not going to survive for 20 years, or whether it should be designed so as to be likely to survive for 20 years, or constructed or designed, because that is not breached. That's breached at the time of building or design, isn't it? Construction or design. It's not a warranty, in other words, which comes on to the nature of the warranty, or if you call it a warranty, which you're contending for. It's the warranty that it will last for 20 years. Then this time limit point may have validity. But if it's a slightly different warranty,
Yes.
that to do with its design and construction, then this isn't a problem anyway, is it?
Yes, my lord.
I mean, your case has been put on the former basis, as I see it. Am I right? Relying on two particular provisions, you've been
Yes.
saying that this is effectively a warranty that this will last for 20 years.
For 20 years, yes, my lord.
But my lord's point is a different way of perhaps putting your case.
I mean, we were wondering whether your case might be better put in terms of how it's designed and constructed, rather than a warranty it will last.
The warranty would simply be that the design was such as would reasonably be expected to give rise to a life of 20 years.
Yes.
That would then be consistent. Your two little clauses, which stick out on which you rely, would actually then be consistent with the general run of the design clauses, so that wouldn't be this problem of inconsistency. Quite where it leads in terms of analysis, though, is there may be problems which we haven't foreseen.
My lords, would it be convenient for me to move on at this juncture?
Quickly, yes.
Since I have an idea I'm going to...
I think that's a nonny question.
My lords, next, J101.
Yes.
This is the code with which the contractor was required to
Yes.
comply. But, my lord, before before diving in, my lords, just a word or two, if I may, about the expressions design life and service life. It has been observed, I think perhaps on both sides, that these provisions are not expressly defined, either in J101 or in the technical requirements. But, my lords, I think there's nothing between the parties as to what they mean. We have offered definitions. My lord, it's our case at paragraph 32. This is core tab E1, page 110. Paragraph 32. Rule 32.1 deals with design life and denotes lifetime the lifetime of the structure which the designer chooses or is required to adopt when undertaking his design. And, my lord, service life, the same as operational life, we would submit, denotes the anticipated life of the structures in service.
Well, the design life will normally be a bit longer, will it, than the service life?
My lord, it appears generally contemporaneous.
Well, they're the same, yeah. One might have understood that.
One
Yeah.
sees in J1 a provision which said that one should be based on the other.
You don't over-design, you just do it to the actual service life.
Ordinarily, yes, my lord. Turning then to J101, my lords, 3 points for present purposes. Firstly, the aim was to achieve a nominal annual probability of failure, known as the target safety level, of between 1 in 10,000 and 1 in 100,000. Secondly, so my lord, the first point is target safety level. The second point is that in designing for environmental loads, J101 in effect required the designer to take into account the 50-year condition, say the 50-year storm, but not the 100-year condition, the 100-year storm. And Lord, thirdly, in designing for fatigue, design life was to be based on service life. My lords,
So your third point in designing for fatigue?
in designing for fatigue, design life was to be based on service life.
Thank you.
My lord, the first point what one gets from Mullin and Friends' case, paragraphs 27 and 28, where it's summarized conveniently, core volume E2, core tab E2 at 137.
Yes.
Lord Mullin and Friends say, as to the safety approach, the approach taken in J101 is by way of a classification of the structure within a safety class, for which a nominal annual probability of failure is defined. That is the target safety level. For J101, the result is a range, 10 to the minus 5 to 10 to the minus 4. And he mentions the explanation, which is that structures in wind farms fall within 2 different safety classes. And, my lord,
It's rather unusual and slightly sort of concerning that we don't seem to have actually J101 to look at. It seems to be a rather important document. One doesn't have a feel as to precisely what it looks like. Or, can you? Is it somewhere? I mean, we've got extracts from it. Am I right? We haven't got the whole document.
we have got the whole document.
We have. Oh, can you just show us?
Additional volume K at K2. Sorry.
Where is it? K2. Oh, here we go.
I'm reminded, my lords, that we haven't now got quite the whole thing, but we've got, I suspect, certainly enough of it. And my lords, for this point, one can go to
The 777.
I'm sorry, my lord, I've slipped a reference. Lord, it's page 777, as you say, paragraph C200, target safety. And at 201, you see the target safety level for structural design to the normal and low safety classes. According to this standard, is a nominal annual probability of failure in the range of 10 to the minus 5 to 10 to the minus 4. That is explained. My lord, that is, it is common ground that that is what J101 aims at. The scheme of the code is that it imposes various obligations on the design engineer, such that, if complied with, the result will be that safety level, that specific annual probability of failure.
How does one measure whether one's achieved that probability?
My Lord, it's not open to those not privy to the genesis of J101 to do that.
No, I appreciate that, but I'm just wondering how it's all very easy. Is it a matter of judgment whether something's within that range? Because you can't sort of can't statistically do it by having a lot of things and seeing how many of them fail in a year, particularly as you're looking at 1 in 100,000 or 1 in 10,000 years, I think.
Exactly.
So it's a judgment thing in the end. It looks rather good in terms of figures, but actually it's...
My Lord, it's a confidence thing. The code has been devised as a result of a good deal of research.
I understand that. All I'm trying to say is how does one act... It's out of interest. If there's no easy answer, I don't want to waste time on it. I'm just slightly puzzled as to how one actually measures whether something has a 1 in 100,000 chance of failing in a particular year, or whether in the end it's a matter of judgment.
My Lord, my understanding is that engineers accept if they've complied with the requirements of J101, then that will be the result.
I see, yes.
But how do you know whether you have?
Because J101 says so.
Yes, my Lord, it's as I understand it, it's as long and as short as that.
Right, well, that's very helpful, thank you.
My Lord, the next point was about the environmental conditions which are to be taken.
Yes.
My Lords, you've seen references to ULS, ultimate limit state. My Lord, that means the limit of load carrying capacity of a member or structure. Engineers also refer to ULS design. That means designing so that capacity to carry load exceeds the design loads. Lords, as I've mentioned, most significant loads on a structure of this kind are environmental loads, wind and waves.
Wind and waves, yeah.
And J101 tells the designer which conditions have to be taken into account in order to achieve the target safety level. My Lord, it's common ground that the conditions which have to be taken into account are effectively the 50-year storm and not the 100-year storm, the 50-year wave and not the 100-year wave.
Well, where is the reference to this?
My Lords, my learned friends have summarised it in their case,
Yes.
paragraph 22, and that's at core E2, page 136. And Lords, what my learned friends are doing there is summarising, and we agree. If you look at subparagraph 2, 22 brackets 2, the 98% quantile corresponds to a load or load effect with a return period of 50 years, effectively for present purposes, the 50-year storm or the 50-year wave. My Lord, the reference in J101 is volume K2,
Yep.
page 792.
And this is agreed, is it?
Yes, my Lord. The text directs the designer to table B1, and if you look at the columns,
I see a 98% quartile is 98 out of 100,
Yes.
which is 49 out of 50,
yes,
which is therefore 1 in 50 is that right or not?
yes. Well, my Lord,
Was that okay?
one has to be careful about the terminology. The terminology is best explained by reference to table B2, which is said to be explanatory.
Yes, I see.
At line 2,
Yes, that's right, 98%
Yeah.
quantile is
Yes.
50, yep, that's right, yeah.
my Lords, to the layman, the idea occasionally arises, well, that's the wind that comes along once in 50 years. That isn't right, my Lord. it can come along in any year. Its definition is that it is the condition which, the chance of which occurring in any 1 year is 1 in 50.
So you could, if you were unlucky, have it 3 years in succession.
Yes.
Yeah, of course.
And, my Lords, of course, what J101 is doing is, on the ground from what I've shown you, is requiring the designer to take into account the 50-year storm and the 50-year wave. And what the code permits the designer to do is to exclude from his calculations the 100-year wave and the 100-year storm, the more remote risks. My Lords, the third point arising out of J101 was the design life for fatigue. You'll have seen references to FLS, fatigue limit state. It means the limit of a member's capacity to withstand fatigue. And in designing for fatigue, of course, the objective of the engineer is to build in sufficient capacity to withstand the expected fatigue loading. Fatigue loading comes in load cycles, my Lord. It is time dependent. And as in any other time dependent condition, it's necessary for the design engineer to have in mind when designing a design life. This is the very purpose of the design life, to work out what the overall cumulative design fatigue load will be. The designer is required either to decide upon or to be given a design life. And, my Lords, in J101, there is some indication of the point I was addressing a moment ago, that design life is based on service life. Would you just look, please, in J101, this is volume K2 at page 820.
Right.
The right-hand side of the page,
Yes.
you'll see the heading K fatigue limit states.
Yes.
The reference is paragraph 104. I think it's K104, my Lord. It reads, the design life, the design fatigue life for structural components should be based on the specified service life of the structure. And then there's a default provision: if a service life is not specified, 20 years should be used. Lord, it's the first sentence upon which I rely. It demonstrates that the expectation is that design life will be based on the specified service life. Lord, there's another provision which is to the same effect, not necessary to turn it up. It is C102, and that's to be found at page 828. My Lord, sir, those were the points I had in mind to draw to your attention in respect of the...
Can I just ask, insofar as your case can be put simply, is it possible to say the design wasn't capable of lasting for 20 years because, and in fact, the design fatigue life wasn't up to that either because of the weakness in the arrangements related to the grout?
The former, certainly, my Lord. I don't think the question of its ability to withstand fatigue has been investigated at all.
I see, it wasn't. So
it failed.
All right. Which provision is it of this which you would say was breach? I mean, you specified this. Their case, as I understand it, is that if you look at another section which you haven't directed us to, there was a specific requirement to produce the foundations in a way which meant that they wouldn't be capable of standing up for 20 years or would be unlikely to be.
My Lords, I don't think that's the respondent's case.
What is their case then about the ultimate limit states, if you look at page 826, which is where the error occurs, doesn't it?
Yes.
It's the first one, the interface shear strength in the left column due to friction may be taken as.
Yes.
And so they say, presumably, well, we took it from you and we designed according to that.
Yes, my Lord.
And you say what in response to that? There was an absolute obligation undertaken, is one
Yes.
way of putting it. Do you also say they were under an obligation to design over and above this or differently from this, although you told them it may be taken as, that they were obliged to buy this document, other parts of it, or on some other basis to produce a different design?
Lords, in the appeal, we rely upon an absolute obligation.
So it's simply the absolute obligation point.
At trial, we advanced 4 allegations of fault. In the end, we managed to establish, either at trial or in the Court of Appeal, breach in respect of 3 of the 4. But, my Lords, neither the first instance judge nor the Court of Appeal were with us on causation, so that the breach took us nowhere.
So, I mean, the answer is, as regards general allegations of design, it's not open to you to say this was, they had a duty to design properly or design around this shear strength provision or independently of it, because as a matter of causation,
Yes.
the judge has found against you.
Yes.
So I don't allege a fault-based failure to comply with this. So, my Lords, subject to one point I'll come to in just a minute, they designed in accordance with this code. They adopted the parametric equations which you've heard referred to and which are found on this page, including, well, to be accurate, they adopted the first of the 2 because they didn't use shear keys. And so the parametric equation that they adopted was the one which had the disastrous error in it. But, my Lords, they weren't to know that, and I don't, in this court, allege that they were at fault in taking that. So, my Lords, in this court, what I rely upon is the absolute obligation.
As to 20-year design life.
Yes. No, my Lords, as to 20 years service life. That the foundation...
You don't complain about the design at all, because you've lost on that now.
I've lost on that.
You complain, you say that there is to be found here an absolute obligation, that it wouldn't fail for any reason, even a hurricane?
Well, my Lords, it failed under normal conditions. The result of that is that we haven't investigated what the ambit of the obligation might be in terms of conditions.
But it's quite important, isn't it? I mean, if you're saying that irrespective of quality of design, even if you designed it so it would only fail once in 50, nonetheless there's a result-based obligation that it would survive for 20 years, that means abandoning the 1 in 50 notion, doesn't it? It means that there's an absolute obligation. It won't. Yeah.
But, my Lord, the matter of the conditions under which it was to survive is a matter of some little complexity. The way in which this contract was constructed, MTH were required to assume certain certified metocean conditions. And, my Lords, had it failed under more extreme metocean conditions than were certified, I apprehend that MTH would have advanced the defence, oh, well, you certified these conditions, the circumstances in which the structure has failed were more severe than those conditions, and we're not responsible. And, Lords, that is a matter which was considered in two cases which are in the authorities bundle. But, my Lord, it's not a matter which has been investigated in this case because the structures failed soon after completion, before the end of the defects liability period, and indeed in normal atmospheric conditions.
So where is this part of your case summarised in your skeleton, in your case?
Lords, I don't know that there's a place where that specific formulation is addressed. What we do, Lords, is we address the cases to which I've just referred under the heading Other Authority. It's E.ON 122.
That's the Canadian cases, yes.
Lord, that refers to the Canadian cases, but this particular point is one which came up in the Australian case, Barton and Stiff,
Yes.
paragraph 89. And at paragraph 89, we point out that the question of the conditions under which the bricks failed were considered by the court, and it was held that the bricks were to be proof only against groundwater conditions likely to be encountered on the land. My Lord, I put it shortly because in deciding the matter that way, the judge relied upon the judgment of Lord Roskill in the court, Lord Justice Roskill, as he then was in the Court of Appeal in the IBA case, which appears on the following page at paragraph 90. My Lords, you will no doubt recall the case of IBA against EMI. It concerned a radio mast, a television mast, I should say, at Emley Moor, which collapsed. The cause of the collapse was asymmetric, I'm going to forget the expression now, loading, but, my Lords, it was held that that asymmetric loading had occurred under normal weather conditions, let's say foreseeable weather conditions. At first instance, Mr. Justice O'Connor held that the subcontractors were guilty of negligence and the contractors were responsible to IBA for that negligence. In the Court of Appeal, the finding of negligence was reversed, and the decision in the Court of Appeal went off on the basis that there was an implied warranty of fitness for purpose. And in that connection, Lord Justice Roskill had occasion to consider what conditions the mast was to be fit for. And, my Lords, he held that the obligation, an implied obligation for fitness for purpose, was that the mast would be proof against any meteorological conditions likely to be encountered in the area. So, my Lord, that's where we, in the part of our case where we address this matter of the conditions under which a structure fails when there's a fitness for purpose warranty. We make the point at paragraph 92 that the point doesn't arise in the present case because the foundations fail under normal conditions.
You were taking us to technical requirements.
Yes, my Lords. Firstly, a short point about authorship. The Court of Appeal described the contract documents as being of multiple authorship and containing much loose wording. My Lord, not necessary to turn it up. It's paragraph 71 and it's core G2, page 171. My Lords, we have some evidence of authorship of the technical documents in question. And, my Lords, it's summarised in the judge's judgment at paragraphs 95 and 96. This is Mr. Justice Edward Stewart. It's core G4 210.
Yes, paragraph
And
95.
95, yeah.
95 and 96, my lord.
No, I don't.
We call the witness Mr. Holt, a structural engineer of some experience, who was employed by engineers KBR until about September 2006. The judge says that he was engaged by MTH. My lord, that's a slip of the pen. He was engaged by E.ON, as he confirmed in his oral evidence and as is reflected in the transcript. The judge says he was employed to carry out some work in relation to the preparation of the specifications and technical documents for Robin Rigg. My lord, reference to the transcript shows that, reference to his witness statement shows that he was engaged in preparing the foundation specification. My lords, we have that witness statement if it's necessary to refer to it. And my lords, at paragraph 96, the judge says that Mr. Holt remained involved until after the 2006 tender. My lords, from that we get that in all probability we would submit Mr. Holt was engaged in the preparation of the foundation specification all the way through up until at least the invitation to tender, which was in May of 2006. My lords, you will ask me why I make a point about authorship. The answer is, my lords, that it goes to the degree of emphasis which is to be given to the factual matrix. I have in mind my Lord, Lord Justice, Lord Hodges' a judgment in capita at paragraph 13. Our submission is that this case is one which is principally capable of being determined on a textual analysis. But, my lords, we recognise that there is some loose wording, and it may be that there are some respects in which the background is relevant. Lords, moving on. Some short points about the technical requirements. My lords, the first is concerned with how the maintenance regime is dealt with. The second is the requirements for certification of metocean data. And the third is a point about the layout of the requirements. Perhaps I can take them swiftly. My lords, my learned friends have developed an interpretation of some of the words upon which we rely, suggesting that they're concerned only with maintenance. This is, my lords, the respondent's case at paragraph 38.7. That's core E2143. And, my lords, the reference is to one of the provisions of the technical requirements upon which we rely, TR 3222, and at subparagraph 7, the respondents submit that, understood in the light of the background summarised above, the second sentence is concerned with requiring MTH to do something, that's to say, to design foundations on the basis that there is to be no planned maintenance over 20 years. My lords, in due course I shall submit that that's not a meaning which is open to the court on the wording of that particular provision. But, my lords, in the technical requirements, it's clear that there are several other provisions which deal with maintenance. Perhaps I can invite your lordships firstly to the key functional requirements. My lords, for this we need additional volume I and tab I5. The page is 354.
Yep.
You see the heading Key Functional Requirements. My Lords, the second paragraph, the works, together with the interfaces detailed in section 8, shall be designed to withstand the full range of operational environmental conditions with minimal maintenance. And my Lords, you also see on the opposite page, subsection 162, operation and maintenance philosophy. The employer's requirements with respect to operation and maintenance strategy are contained in Part I, Section 5. Lords, I'm sorry to say that Section 5 is one of the sections that we don't have.
Right.
My Lords, there are further references, however, in Section 10 of Part I. My Lords, for this we need tab I9, page 520.
Page 530.
520.
520, yes, got that, yeah.
And my Lords, this is Section 10, Structural Design and Fabrication. And my Lords, just a couple of references there. At page 524, under the heading 10.1.5, Design Verification for Strength, Stability and Fatigue Endurance. So this is fatigue, my Lord, but the provision is the fatigue assessment, this is the third paragraph, shall show a fatigue lifetime of a minimum of 20 years with no requirements for inspection or maintenance. And my Lords, a similar provision at 529. My Lords, here is at the foot of the page, subsection 10.5.1, grouted connection, the second sentence. The connection shall be designed to require no scheduled inspection or maintenance. So, my Lords, that's the way in which the maintenance regime was dealt with. If I might move on to the matter of certification of the Met Office data. My Lords, this is still the technical requirements. And, my Lords, it's, I can go, I think, straight to tab I6. And, my Lords, at the top of the page, introduction, the third line.
Which page is this?
I'm sorry, page 360.
Thank you.
I6, page 360.
Thank you.
The third line, its use is intended as follows, that's to say the design basis, and at the second bullet point you see provision of certified site conditions by the employer for incorporation into the contractor's design basis for detailed design. And, my Lords, halfway down the page, a sentence beginning, a paragraph beginning, the employer shall provide, you see the employer shall provide certification of the site conditions as described in Volume 2, Part I, Section 4, by DNV prior to the commencement date. The certification applies only to, and then you see, my Lord, the first bullet, site wind and metocean conditions. So, my Lord, some metocean conditions to be certified and to be incorporated into the contractor's design basis.
What is certification described in Volume 2, Part 1, Section 4? Do we have that?
We do. Lord, it's tab I8. And if you take page 514, under the heading General Provisions, the second paragraph, with respect to certification, the employer shall
Yep.
obtain the certification at 4.5. And my lord, 4.5 is at page 518, which is entitled Certificates and Statements of Conformity. And at page 519, one has the second paragraph, the following certification shall be obtained by the employer. Verification of the site conditions in Part I, Section 3.4, the site wind and met ocean conditions. So, my lord, that is the provision for certification of met ocean data. My lords, in view of the time, I will move on to the other point, which concerns the layout of the technical requirements. Could I invite your attention, please? My lords, the reference here is to the Court of Appeal's judgment, where they suggested that the provisions upon which we rely were tucked away rather than being prominent. On our case, my lords, the provisions upon which we rely are prominent because they appear in the conditions of contract. Well, I've already dealt with that. But we also rely upon clause 3.2.2.2. We say that also is prominent. And, my lords, in that connection, we invite attention to I6, page 356.
Righto. Yes.
This is the employer's design basis. And, Lord, the next page, page 357, one sees the contents which show the layout of this part of the technical requirements. And you see introduction with preliminary references to tender design and detailed design. Then you see 3.2 design principles. And, my lord, again, 3.2.2, general design conditions, and at 3.2.2.2, the detailed design stage. Lower down, my lord, you also see 3.4, site wind and met ocean conditions. Those were the certified conditions. My lords, the point is that 3.2.2.2 is relatively, we would submit, prominent in the layout of this provision. My lord, the relevant provision is to be found on page 366, which I anticipate that your lords will already have, my lords will already have looked at. Lord, perhaps one aspect of its prominence is that it comes immediately after an important provision about the detailed design, namely that which requires the integrated analysis. This is the first 3 lines of the first paragraph under the heading Detailed Design Stage. My lords, your attention has been drawn to the fact that this set of technical requirements requires the designer to adopt the technique within J101 known as integrated analysis, an important matter. The provision upon which we rely, which follows immediately thereafter, is therefore, we suggest, prominently placed. My lords, it's with some dismay that I come then to the end of the points I wanted to raise with the technical requirements and find that I turn to submissions at a point in time when my time has expired. My lords, I will seek to deal with the submissions shortly, and may I start by saying that I have some submissions about the text and submissions about the context. I propose to take submissions about the text first. My lords,
I suppose at the moment we see how we go, but you'll be eating into your time for reply.
Yes, my lord, of course I
Started a bit late.
But yes.
Start late.
Well, we did start late, but you've budgeted on the basis that we have 4 hours.
Yes.
Right.
So where are we in your skeleton of your case now?
My lords, I had not tied these submissions directly back to specific paragraphs of the case. However, I will endeavour to do so.
Don't worry. Take your own course.
My lords, I firstly had in mind to make three submissions about the conditions of contract. Lords, the first is this. We submit that it would be wrong to marginalise the references in the conditions of contract to fitness for purpose in the conditions of contract. You have seen that they appear both in 8.1.10 and in 32D. My Lords, had the parties themselves intended not to give effect to those provisions, one might expect them to have adopted the drafting technique which inserts the words "not used." My Lords, that is a technique which we see used in this very contract in numerous places. Might I just briefly invite your attention to the contents to the conditions of contract. My Lord, it's tab I6. I'm sorry, I3.
Yep,
Page 244.
yep.
And, my Lords, if you look at the very top of the page, conditions of contract, interpretations, and the very first item, 1.1, not
Sorry,
used.
244, did you say?
Yep,
Not used, yeah.
conditions of contract, it's the index, yep, contents, yep.
I'm sorry, it's the
Sorry, I'm
contents.
not on the right page. The contents.
I'm sorry, I3, page 244, my Lord.
Yep,
And, my Lords, there are a number of references to clauses being not used, both in the contents and in the text. And to take an example, perhaps an important example in the text, would you turn to page 260, which is clause 8.1, and turn the page to see Roman 14 on page 261. You see not used.
yes,
My Lords, the submission is, had the parties intended not to use 8.1.10, they might have used that expression. And similarly with 32D, indeed, as a matter of drafting, one might expect them to have used not used at 32D if that was their intention.
I see.
My Lord, the second submission is that the reference to good industry practice did not qualify the obligation at 8.1.10. My Lord, this is a point which is developed in the case. My Lord, it's core E.ON 116.
Yes,
And paragraph 57 and following. And my Lords, we rely on the points there made, and to save time, I shan't repeat them. May I just add one point, my Lord? The introduction of the expression good industry practice at 8.1.10 does, we accept, present something of a conundrum. Why is it there? But, the Lords, we do submit that it doesn't seem to need to be there to introduce an obligation to comply with good industry practice. My Lords, because that is already to be found in the preceding subclauses and indeed some of these subsequent subclauses of 8.1.10 itself. Lord, good industry practice comes up at 8.1.4. This is, my Lords, page I3, page 260, and 8.1.5, and it comes up again at 8.1.11 and 8.1.12.
yes,
9 as well.
9, yep.
Yes, I'm so sorry, I overlooked 9.
Well, isn't it a sort of tag on which they put in everywhere?
Not quite.
Well, my Lord, there is some evidence of a mantra being adopted.
Yes.
And if necessary, we would submit that the mantra has been misapplied at 8.1.10.
Right?
Lord, the third point is that the conditions of contract we submit presuppose that the purpose for which the foundations were required would be discernible from the employer's requirements. At 8.1.10, of course, we find the expression determined in accordance with the specification.
Yes.
And in the definitions, a rather different expression, my Lord.
So that last reference, I'm so sorry.
Yes, that's
It,
I3, page 260, clause 8.1.10. My Lord, so far as the other reference, which goes with clause 30.2d, the defined term fit for purpose, my Lords, that's at I2, page 236. And we see that the means by which the purpose is to be identified is slightly different, in accordance with and as can properly be inferred from the employer's requirements.
Yes.
My Lords, the point is that plainly we suggest both presuppose that it will be possible to discern the purpose, at least by inference, from the employer's requirements. My Lords, I then come to some submissions about the technical requirements themselves. Might I start by inviting your attention to our case?
Yep.
This is E.ON 109 at paragraph 31.
Thank you.
My Lords, what we did, we hope it was helpful, is we extracted a series of 7 provisions from the technical requirements, which have attracted a certain degree of focus in...
That's helpful, thank you.
And, my Lords, the Court of Appeal was minded to distinguish between the two which used the ensure wording and the remainder, holding that the two were inconsistent with the remainder. My Lords, for present purposes, I will call the two which refer to the expression ensure as the ensure wording. My Lord, they're to be found on page 109. It's TR 32222.
Yes, indeed.
And at the foot of the page, TR 3B51, which go together, both adopt the ensure wording.
Right.
The remainder, my Lords, may be regarded as wording which is directly concerned with design, that's to say, indicating to the designer that he's to adopt a particular design life. And in each case, the word minimum is included. But, my Lord, I will refer to those as the design life wording. In terms of submissions, my Lords, the first is that the purpose for which the foundations were required is implicit in the design life wording. Lords, I take by way of example the first which you find on page 109 at the top. It's T1.63.
Yep.
My Lord, it refers in terms to a design life of 20 years. My Lord, given that we know that a design life is to be based on the service life, it is implicit that the service life was to be a minimum of 20 years. My Lords, we say that goes for the other design life wording as well. The second submission we make is that in respect of some of the design life wording, the purpose is explicit. My Lord, an example is the third one on the page, TR 3.2.6, where you see, my Lords, the expression service life actually used in the second line.
Yes.
So, my Lords, taking the design life wording, we say that the purpose, a service life of 20 years, is either implicit or explicit. My Lord, we say that the explicit purpose, the other provisions which explicitly show the purpose are over the page, my Lords. It's the one at the top, T3B56, and the last one, TR 1024-9. My Lord, the third submission we make is that the purpose is also explicit in the ensure wording. My Lords, you're familiar with the ensure wording. You see it, it's the second item on page 109, T 3.2.2.2.
It's in there, yeah.
It refers to a lifetime of 20 years. My Lords, we suggest that that is plainly a reference to a service life of 20 years. My Lords, the last point we make about the technical requirements is this. We submit that it would be wrong to submit that TR 3.2.2.2 is exclusively concerned with maintenance. My Lord, this is a point which is developed in our case. It's at page 117, so that's core E1 117, starting at page 65.
Yeah, paragraph 65, yeah.
And, my Lords, I don't seek to repeat what is said there. I simply seek to add this. There are, if you would be good enough to look back to the wording, it's on page 109. This is T32222. The first sentence, it's the second line, in every aspect without planned maintenance. Lords, just 6 words. It suggested that they change the meaning of the entire provision. Lords, our submission is that those words are additive rather than qualifying. Lords, what they do is they add to the obligation which is enshrined in the opening words of the paragraph. And so, my Lords, putting those 4 submissions together, we submit that both by express reference and by inference, the technical requirements convey the purpose for which the foundations were required. And, my Lord, with that I had in mind to move on to the context and to make 3 submissions.
Yep.
My Lords, the first is that there was no inconsistency between the warranty contended for and the obligation to undertake a probabilistic design. My Lords, this is a point which is developed in the case
Yep.
at E1, page 109.
Yep.
It's paragraph 31 and following.
Right.
And, my Lords, the point made there can be summarised. Whereas the Court of Appeal treated the ensure wording and the remainder of the technical requirements as pointing in different directions, we respectfully submit that the court overlooked the necessity to look back to the conditions of the contract for the purposes of reminding itself of the question which it was seeking to address. My Lord, that's summarised at paragraph 36 on page 111. And, my Lords, I needn't repeat what is said there. Our submission is that in this part of the judgment, the Court of Appeal lost sight of the need to consider whether or not the use, the purpose for which the foundations were required was something which was discernible, and rather it addressed the problems within the technical requirements as being a contest between two different groups of provision.
How far does your argument on purpose depend upon the two provisions, which use the word ensure?
Yes.
If they weren't there, would you have the same argument?
I would, my lord. I was seeking to address that in the submissions I made about those provisions a short while ago. I started by saying that the purpose was implicit within the design life.
I thought so. So that is not, and putting it the other way around, ignoring the purpose clause, which we find at 8.1.10,
Yes.
are the two provisions by themselves good enough for your case in your submission?
My lord, yes. They bind MTH, but, my lord, we insist upon our alternative formulation by reference to the conditions. We rely, of course, not only on 8.1.10, but also on
30.2, yeah.
And, my lords, one reason for doing that is that they take priority in the hierarchy of documents, as I showed you somewhat earlier, by reference to paragraph 5.3.
Yep.
So, my lords, we say that when properly understood, those of the provisions in the technical requirements which identify the purpose can be regarded as not inconsistent with but complementary to the obligation to undertake a probabilistic design in accordance with J101. That design created a structure which, as Lord Justice Jackson said, would probably stand up, but there was a risk that it might not. And, Lords, the risk of that it might not is something that was, by means of the warranty upon which we rely, allocated, as between the parties, to MTH. Lord, that's the point we make it in the case at paragraph 15.
Thank you. Yep.
My Lord, it's E1.
Page 105.
105.
Yep.
Page, paragraph 15.
Yep.
Lord, I won't repeat it.
Nope.
My Lords, the second point in relation to context relates to latent defects again. But, my Lord, it's different in kind, I think, from the discussion, the points which were discussed earlier. In the respondent's case, they develop the submission that, to paraphrase, a claim under the warranty upon which the appellants rely doesn't look very much like a claim for damages arising out of a latent defect. Lords, our answer to that is simply this. We suggest that it looks very much like a claim for damages for a latent defect. What one asks oneself could be a more typical latent defect than that the structure has been built. It appears to be in a shape which complies with the requirements. There is, although nobody knows it, an underlying error in the code which has been adopted. Lord, that is a latent defect. It became patent only when the structures failed.
Yep.
And, my Lord, the last point I had in mind to make is this, that the risks which were allocated to MTH by virtue of the warranty upon which we rely were remote risks. Lord, this is back to the paragraph which I invited your Lordship's attention to a moment ago, paragraph 15 of the case.
Yes.
E1 105.
Yep.
The design is, the probabilistic design is intended to cater for numerous risks, including some quite remote risks, but the very most remote risks are ones which are not catered for in design. So that when Lord Justice Jackson says, well, a probabilistic design is such as to create a structure which will probably stand up, but might not, the risk that it might not is itself a very remote risk. By reference,
J101 is accurate, yes.
yes, if J101 is accurate. And my Lord, the point about that, and why I mentioned it as part of my submissions on context, is that it sheds light, we suggest, on the commercial background to the parties' agreement. They agreed terms which required MTH to undertake that the structures, when completed, would be fit for the purpose of supporting the superstructures for 20 years. They knew that J101 would probably do that. The chances of it not achieving that were very remote. It is those chances which they accepted. It's a matter of allocation of risk.
When you say were very remote, were thought at the time to be very remote.
Precisely so, my Lord. I accept the qualification.
Why should they, I mean, if one is talking risk, why should they be supposed to have taken the risk of J101 not being accurate?
Well, my Lords, it's...
Why wouldn't one construe these design obligations, whatever they are, and fitness for purpose, as meaning in all respects outside the scope of what is required by J101 or what is contemplated by what is provided by it?
My Lord, not, I think, argued, and indeed we would submit, not open on the text of the contract. This is, we would submit, if the court were with us, on the identification of the purpose, a contract which in two separate places imposes an obligation as to fitness for purpose. Lord, that is an obligation which embraces not only the known risks, the remote weather events, which I was referring to earlier, but also to any other risk, such as a code error. My Lord, there are many uncertainties once a design of this nature has been completed. Another which arises is what is known as modelling error.
Yeah, the short point is that it was going to be built according to J101, and the question arose, who took the risk that J101 mightn't work?
Yes.
Yeah.
My Lords, 2 points I should mention very briefly in closing. Shear keys. Lords, you've seen submissions which go to the question whether the cause of the failure was the decision not to use shear keys or whether it was the error in J101. Lords, it's part of my case, as I've sought to explain, that the error in J101 was part of the remote risk which was allocated to MTH. Given that that's part of my case, my Lord, the possibility that there might have been another way round is not material to your Lordship's determination.
Thank you.
My Lord, the other point is this. There is a section of our submissions under the heading minimum design life of 20 years, in which we develop arguments about the use of the expression minimum and the sort of steps which the contractor might have taken to mitigate the risks which were imposed upon him. My Lord, the genesis of that was interchanges in the Court of Appeal.
Yeah.
But, my Lords, your Lordships are not concerned with whether it was possible to mitigate the risk.
No.
Your Lordships are concerned with whether the risk was allocated to MTH.
Exactly.
And in those circumstances, my Lord, I doubt whether you need to be concerned with that part of the submission.
So paras 49 to 56 maybe don't take matters much further. Very well.
My Lords, unless there's anything further, those are my submissions.
Thank you very much indeed. Thank you, Mr. Marin. Mr. Buckingham.
No submissions.
Very much. Mr. Stredfield James.
Would you like me to start for I'm happy to do...
I think so, because
Topic,
at
that's
the moment
fine.
it may be Mr. Marin has 3 minutes to reply in due course, but yes.
perhaps then to try and do something which is relatively self-contained before lunch. If we start where Mr. Marin started and to look at the case at core page 70.
Thank you.
Mr. Marin started, as your Lordship will recollect, with looking at this diagram of the tower.
Yes.
And I just want to pick up how the design works a little bit more, and then we'll come back to J101 immediately after the break. And Mr. Marin helpfully identified the turbine tower as standing above the foundations, and he gave you some measurements, 80 metres.
Yep, and another 44 for the
Exactly.
rotors. Yep, blades, yep.
Now, the importance of that and understanding that is that the foundations that sit below it don't just support it in a way a house does, there's something that sits above. It's intimately affected by the behaviour of what goes above. One can think about that just as a matter of scale, if you've got 80 metres affected by wind. And that's important because of the phrase that Mr. Marin took you to later on about integrated design.
Yes.
So if we just pick that up very briefly before the break, and if we go to I5
Yes.
at 354.
Yep.
You've seen parts of this before, but under 1.6 key functional requirements, you see that, first of all, just by way of text, you see that all the paragraphs start slightly differently. The first deals with the wind farms,
Yes.
the second deals with the works and the works elements and so on.
Yes.
Just dealing with the wind farms, they're to be designed, constructed and operated to provide the lowest lifetime cost option capable of meeting the full lifetime requirements. Maximum output, minimum maintenance, maximum availability to generate are prime requirements of the scheme. Now, those are much wider than just the question of the behaviour of the foundations, and one apprehends that probably those words wind farm is taken from a generic description of the project, which is bound in here. But if one then tries to see how it works in terms of the design, if one moves now to our favourite TR3222, page 366,
Yes.
but look at the first paragraph,
Yes.
which we've just referred to, but I think not looked at. The first section we'll come back to after lunch identifies J101, first two lines. But then after that, it says such method is referred to throughout this document as an integrated analysis, and Mr. Marin mentioned that. Then it says the design shall be optimised using an integrated foundation, transition piece, and tower model. Now, the tower model is the bit that sits above the foundation, and reading on with combined wind and wave loading, and that's because of the length of the tower being way above the length of the transition piece. The foundation contractor shall supply such pile head stiffness matrices and other information as is necessary. The design should be optimised using an integrated tower foundation and tower model. The foundation contractor shall supply such pile head stiffness matrices and other information as may be necessary to complete the integrated analysis, which will be performed by the turbine contractor. So what's going to happen under this contract is that the information from the foundations and the information from the tower are going to be brought together to produce an integrated design for the whole thing, to be carried out by the turbine manufacturer. And again, just one more before lunch, we can see the way that that works. If one goes to Part I, Section 10, page 525, that's behind tab I9.
Yes.
Now this deals with, on the bottom of the left-hand side, 10.2.4, geotechnical design.
Yes.
And what's happened, and I won't take you to the references now, but there's some additional site data that was produced before tender, but after the indicative design had been produced. And you can see that at the top of page 526, there's a reference that's detailed in Part 1, Section 3. The reference there is pages 391, 392.
Additional sizing. What page is this, sorry?
The reference to Part 1, Section 3 is 391, 392. We don't need to go there.
No, thank you.
Complete an additional site investigation. The contractor shall review the additional site investigation. This is now the important paragraph, the second paragraph. And revise his designs accordingly with a view to optimising the foundation designs at each location. This review shall be carried out in conjunction with the optimisation of the combined foundation and turbine tower structure described in Section 3. That's what we've just seen. That's what the turbine tower contractor is going to do. The contractor is going to allow in his tender for carrying out the review. And then the next paragraph, the review of the design to account for the additional site investigation data and the integrated design and structural analysis shall be completed prior to the date for completion financial design. This design process may result in the necessity to revise the foundation design. Any such design change will only be accepted if this results in a reasonable optimised design of integrated foundation pile and tower structure. And then in the next paragraph, there may be a change to the contract price if there's an increase or reduction in the amount of steel as a result of the design review. That's the optimisation. And you see that in the paragraph starting, the contractor shall provide details.
Last sentence, yeah.
Exactly. So just putting that together, just by way of background, before one starts on actually J101, the scheme that's incorporated by J101 isn't just the optimisation of the foundations, it's the optimisation of the whole tower. That's something that's one of the particular boasts of J101, and you'll see the references to the Tove Feld paper, who's one of the ladies who put together J101. It's in the bundle at K3, page 842, who says that what J101 is a cost-effective standard based upon safety levels, and it allows the optimisation of the whole thing. That's both the tower, for which MTH are not responsible, and the bit below the tower. That procedure was to take place in accordance with the contract J101 standard, but by the turbine contractor, and might produce an adjustment to the contract price. So the importance of this lies just by way of, first of all, background information as to how this works, but secondly, to the idea that, certainly as my learned friend's written case, that there's something that MTH could have done by way of departing from or doing something separate from J101 to, quote, strengthen the design. Because this was going to be an optimised design in accordance with J101, with the actual optimisation being taking place by the turbine tower contractor. That's a very quick 5 minutes. What I was proposing to do next, possibly after the break, but I'm happy to do it now, is to look at J101.
After the break. Thank you very much. We'll resume again at 2 o'clock. Thank you very much indeed. Court now adjourned.